yɛnto akaseɛbɔ no so a na ɛnɛ de yɛde mu kɔpiem wɔ ɛyɛ court ban mu asɛmdibea asɛm ɛyɛ Supreme Court Supreme Court na ɛnan mu ana Supreme Court for the ruling bi ababɛto abɔnten anya asɛm ketewa na wei mu ana ɛyɛ lawyer Tsaatsu Tsikata nso wama ɛyɛ Afinyo Markins Otukunor sɛ ɔmo ho atwitwa fifire efra wɔn paa wɔ court hɔ no ma ɛnyɛ asɛm ketewa. Yɛn na yɛ ne mu nsɛm a ɛkɔ so ɛwɔ yɛ Tsaatsu Tsikata lawyer Tsaatsu Tsikata Mr. Afinyo Markins Mr. Otukunor sɛ Okutunor nso so Otukunor nso awɔ ɛtie biara no ɛkɔ so wɔ mo ntɛm a ɛnyɛ asɛm ketewa. Ɛnan mu ana court ɛfrɛ sankofo mmiɛnsa yi ɛde ruling wi ɛbɛto abɔnten ama yɛ lawyer Tsaatsu Tsikata nso de ne petition ɛde kɔdan court sɛ sei ɛna ɛkɔ so ɛwɔ ɛyɛ sankofo mmienu yi ntɛm a ɛnyɛ asɛm ketewa. Na mmom no ɛyɛ petition na mu aduru yie paa nti court gyina so ɛma kyɛ sɛ nkofo mmienu yi ɛyɛ Otukunor ne ɛyɛ Afinyo Markins yi fifiri fra mu wɔ court hɔ yie paa ɛnyɛ asɛm ketewa. Ewiase deɛ sɛ aban ka wa yɛde to wɔn nsa a waso tumi yɛ hye yie paa fi sɛ bibie no abɛka aban no anaa court no ɛbɛtie fi sɛ ɔno no ɔde mmara na ɛyɛ adwuma sɛ obi a ɛyɛ the 1992 constitution no mu a na kyerɛ sɛ abusuafoɔ deɛ ɛsɛ na ɛfata no ɛno mu na yɛde bɛdiw na sɛ ɔkenkan kɔdu article hɔ no deɛ a ɛde na kyerɛ sɛ abusuafoɔ ɛnyɛ asɛm ketewa na sɛ aban dan a na ɔba bɛhan a ne sɛ ɛno nko ne ɛdan a wohan a yɛnyɛ wo kaprɛ sɛdeɛ 100 years koraa wobɛkɔ.
Tsikata. And Mr. Tsaatsu Tsikata says very clearly that the crisis in our judiciary is far worse than the crisis in our economy. What? That's a huge statement. As if you're talking about the crisis in our economy, you're talking about bankruptcy. You're talking about a country which needs more than 128% of its total national revenue to service debt, pay debts, and pay public sector emoluments. Now, if this crisis is less weightier than the crisis in the judiciary, then we have a monumental crisis in the judiciary. And these are not my words. These are the words of somebody who has been a law lecturer for many years, and who probably was a teacher of some of the people who are sitting on the Supreme Court today. And his verdict is that the crisis in our judiciary is far worse than the crisis in our economy. Now, I watched the proceedings yesterday. You understand? I watched the proceedings yesterday. And I've also read the report of which you read from one of the newspapers, which says that the Chief Justice was angry. You know, I mean, where does anger arise in the work of the Chief Justice? The Chief Justice's role is to impartially, with other judges of the Supreme Court, interpret the Constitution. Where is anger in that? How does anger arise? How does anger become an issue? So I'm just sitting back and wondering, I mean, where is this anger coming from? Okay. Now, I want today just to dwell on principles. Okay? Just to dwell on principles. Ghana has a Supreme Court only because 32 million Ghanaians cannot sit in judgment over cases. Ghana has a Supreme Court because 32 million Ghanaians cannot sit together to interpret the Constitution. So that power of the people, the power, the sovereignty of the people, has through legal arrangements, including constitutional provisions, been transferred to some category of citizens. So when the Supreme Court actually sits, it sits in the name of the people of Ghana. The Supreme Court itself doesn't have any powers beyond the powers that the people of Ghana have vested in the Supreme Court. So at every time when the Supreme Court is making decisions, it should be asking the important question whether it is truly, genuinely, legitimately acting on behalf of the 32 million people of Ghana. That's the test. So at any time when the Supreme Court acts against the expressed, unexpressed will of the people, the Supreme Court's essence, the essence of the Supreme Court is lost. And we have to understand that very clearly. There's a matter of principle. Okay. Now, the Supreme Court interprets laws, including laws enshrined in the Constitution and so on. Eminent jurists have established a principle of law. And that principle of law is referred to as the purposive interpretation of law. Purposive. And this is a principle which is known by every law lecturer, every law student, every law practitioner. Now, what does the principle mean? That principle simply means that in interpreting the law, the general good of society should be taken into account. So at every time that the Supreme Court sits to adjudicate on any matter, it ought to be asking itself whether indeed that interpretation of the law contributes to the achievement of the general good of society. This is an important principle in law. I'm not the one who is coming up with this principle. Now, there's something else which is absolutely important. The general principle is that the Supreme Court expresses the sovereign will of our people and so on. It has to. Okay. But that sovereign will of our people and so on is embedded in the Constitution which the people of this country adopted for themselves in 1992. Okay. Now, at every time, these judges on the Supreme Court and the Court of Appeal and High Court and so on should be asking themselves very important questions. Ghanaian people lost their lives in order to give life to this Constitution. Ghanaian people suffered imprisonment and so on, clear hardships in order to bring this Constitution into being. Now, the question I pose today is whether or not the conduct of judges takes account of the huge sacrifices that the people of Ghana made in order to bring about this Constitution, which makes it possible for us to operate a Supreme Court and which makes it possible for us to appoint a Chief Justice and Justices of the Supreme Court. The people who struggle for this Constitution, to give life to this Constitution, is this the outcome they wanted? Do they want an